State of Cannabis.
This is the State of Cannabis News Digest, a roundup of this week's key developments in the cannabis industry.
Good morning and welcome back to the show. It's Saturday at 9 a.m., which means it's time for our weekly look at cannabis policy across the country. This week, cannabis reform is moving in several directions at once. At the federal level, marijuana rescheduling is already facing a court challenge. In the states, lawmakers are debating everything from hemp rules and THC potency caps to school zone penalties, medical cannabis access, ballot campaigns, drive-thru sales, and cannabis hospitality events. We'll start in Washington, then move through the states where the biggest legal, political, and business fights are unfolding.
And now here is the deeper look at the key events in the cannabis world this week.
Federal cannabis reform is already facing a legal challenge. Smart Approaches to Marijuana and the National Drug and Alcohol Screening Association have filed a lawsuit asking the U.S. Court of Appeals for the D.C. Circuit to review and set aside the Trump administration's marijuana rescheduling order. That order was announced last month by Acting Attorney General Todd Blanche. It moved state-regulated medical cannabis products and FDA-approved marijuana products from Schedule I to Schedule III under the Controlled Substances Act. But the order does not settle the broader federal marijuana issue. A separate administrative hearing scheduled for this summer is expected to consider broader rescheduling, including recreational cannabis products. The lawsuit argues that the order violates the Administrative Procedure Act and Section 201 of the Controlled Substances Act. It also claims the Attorney General exceeded his authority. The defendants include the Department of Justice, the Drug Enforcement Administration, Acting Attorney General Todd Blanche, and DEA Administrator Terrence Cole. The petition was signed by attorneys at Torridon Law, where former U.S. Attorney General William Barr is a partner. For the cannabis industry, the lawsuit adds uncertainty. Schedule III status could reduce the tax burden tied to Section 280E, ease some banking concerns, and support more research. But opponents are now asking the courts to reverse the move. Congress is also involved. A House Appropriations Subcommittee voted last week to block federal officials from taking further steps to carry out cannabis rescheduling. So, the federal picture remains divided. The administration has moved state-regulated medical cannabis products to Schedule III, while opponents are trying to undo that action in court.
In Texas, hemp flower and pre-rolls can stay on shelves, at least for now. A Travis County judge has granted a temporary injunction blocking key parts of the state's new hemp regulations. The ruling prevents the Texas Department of State Health Services from enforcing a THC calculation that would count THCA toward the legal Delta-9 THC limit for consumable hemp products. Texas law defines hemp as cannabis with no more than 0.3% Delta-9 THC by dry weight. THCA is not intoxicating by itself, but it converts into Delta-9 THC when heated or burned. That matters because hemp flower, pre-rolls, and some concentrates are consumed by smoking, heating, or vaping. The lawsuit was filed by the Texas Hemp Business Council, Hemp Industry and Farmers of America, and several hemp businesses. They argue that state health officials do not have authority to change the legal definition of hemp products without the legislature. Judge Daniela DeSeta Little's injunction applies statewide. It also blocks certain hemp transport restrictions, sharply higher licensing fees, and a penalty structure that would count each day of some violations as a separate violation. Retail registration fees would have risen from $150 to $5,000 per location. Manufacturer licensing fees would have increased from $250 per year to $10,000. The order does not block every new hemp rule. Child-resistant packaging, a minimum purchase age of 21, and other consumer safety rules remain in effect. The injunction lasts until a trial set for July 27th, when plaintiffs are expected to seek a permanent block. The state is expected to appeal. At the same time, Texas hemp businesses are facing pressure elsewhere. The Texas Supreme Court issued a separate Delta-8 ruling, allowing the state to treat manufactured Delta-8 products made from hemp-derived CBD as controlled substances.
In West Virginia, the state's highest court is considering whether the smell of marijuana alone can justify a police search warrant for a home. The case began in Martinsburg in 2020. Police were responding to a call about a suicidal woman who had reportedly stabbed herself. Officers could not find her, so they began going door to door. At a home tied to Aaron Lewis, officers said they smelled a strong odor of marijuana. Lewis's son answered the door and refused permission to search. Before getting a warrant, officers entered the home for what they called a protective sweep. Court documents say they saw a bundle of money and 2 clear bowls with a leafy substance on the kitchen stove. Officers then obtained a search warrant. During the later search, they seized suspected marijuana, suspected heroin, crack cocaine, a firearm, ammunition, and cash. Lewis was charged with 3 counts of drug possession with intent to deliver and being a prohibited person in possession of a firearm. But in 2023, Berkeley Circuit Judge Deborah McLaughlin suppressed the evidence. The defense argued that the warrantless sweep violated the Fourth Amendment. Without what officers saw during that sweep, the warrant rested mainly on the smell of marijuana. The judge ruled that odor alone did not establish probable cause to search the home. Now the state is asking the Supreme Court to reverse that decision. An assistant attorney general argued that West Virginia precedent is clear and that marijuana odor provides probable cause. Lewis's attorney argued that medical marijuana legalization has changed the legal meaning of cannabis odor. West Virginia legalized medical marijuana in 2017, and every surrounding state has legalized either medical or recreational marijuana. For patients, the ruling could affect privacy at home. For police and prosecutors, it could change what evidence is needed before seeking a search warrant. The court is expected to rule before its current term ends on June 11th.
In Louisiana, a bill that would increase penalties for cannabis use near schools is moving toward a possible Senate floor vote. House Bill 568 is sponsored by Republican Representative Gabe Ferment. It has already passed the House, and the Senate Judiciary B Committee approved it in a 3-2 vote on May 6th. The next day, the bill was reported without Legislative Bureau amendments and passed to third reading and final passage. The proposal deals with Louisiana's drug-free school zone law. It would apply to people who smoke, vape, or otherwise abuse controlled, dangerous substances on school property, within 2,000 feet of school property, or on a school bus. The school property language includes college campuses. Ferment told senators the bill would create a clear behavior-based offense. He said that when someone is openly smoking or vaping an illegal drug in a school zone, law enforcement should be able to act and prosecutors should be able to prove the case. For marijuana, Ferment said the bill would set a penalty of up to 1 year in jail and a fine of up to $1,000. A representative of Governor Jeff Landry's office appeared with Ferment in support of the bill. Opponents say the measure goes too far. Kevin Caldwell of the Marijuana Policy Project testified that Louisiana already has serious penalties for drug offenses. He said the bill would add jail time for public consumption, not distribution or intent to sell. Caldwell also argued that a 2,000-foot radius covers large parts of many neighborhoods, especially in cities and towns. Louisiana reduced penalties for low-level marijuana possession in 2021, removing the threat of jail time for possession of up to 14 grams. House Bill 568 does not appear to repeal that law outright, but it would create tougher penalties for cannabis conduct tied to school zones.
In Connecticut, lawmakers have reversed part of a recent cannabis policy change and voted to keep the state's 35% THC cap on cannabis flower. The House and Senate voted Tuesday to reinstate the cap after a bill passed in April removed it. Before this year's legislative session, Connecticut law already capped THC content in cannabis flower at 35%. The reversal followed pushback from lawmakers, especially in the Senate. House Majority Leader Jason Rojas told the Connecticut Mirror that the cap was restored after Senate members expressed concern. He said he still did not think the cap made much sense, but lawmakers agreed to it because others felt strongly about the issue. Supporters of the cap pointed to public health. Representative David Ritigliano argued that higher THC concentrations could make it easier for people to become addicted. He also noted that public health professionals had raised concerns about THC levels during a public hearing. Several senators from both parties raised concerns about children and mental health. Senator Christine Cohen said she had strong reservations about THC potency and its impact on mental health. But there was disagreement. Representative Roland Lamar said cannabis plants have natural limits on THC concentration. He also said watering down cannabis could be more dangerous if it involved substances that had not been tested or regulated. Lamar added that keeping the cap may put Connecticut cannabis businesses at a competitive disadvantage compared with some other states. The restored flower cap does not undo all cannabis changes from the April bill. Caps on THC concentrates were eliminated. THC limits for infused drinks increased. The market expanded to include topicals, tablets, and capsules, and out-of-state patients may now purchase cannabis for medical reasons. So, Connecticut is not simply tightening all cannabis rules. It is keeping a limit on flower while allowing other parts of the market to expand. The debate may return next year, with possible discussion of THC limits for edibles, tinctures, and other products.
In Pennsylvania, cannabis policy is moving on two tracks: regulation and the governor's race. First, the regulatory track. The Senate Law and Justice Committee has again advanced Senate Bill 49, sponsored by Republican Senator Dan Laughlin. The committee voted 7-4 on May 5th to move the bill back to the Senate floor. The proposal would create a new independent cannabis control board. It would move oversight of Pennsylvania's medical marijuana program from the Department of Health to the new board. That board would issue permits, write regulations, enforce compliance, and oversee cannabis dispensing to patients and caregivers. The bill would also regulate intoxicating hemp products. Laughlin has said products he described as gas station weed have been sold with little oversight and too few safeguards. Earlier amendments added provisions banning the sale of most hemp THC products to align with a pending federal policy change expected to take effect in November. The latest version also says 3 board members appointed by the governor must have backgrounds in law enforcement, addiction, and cannabis matters. It also says the board cannot authorize recreational sales unless the General Assembly approves them. Another amendment would allow regulators to award additional dispensary permits to certain medical cannabis grower processors that were operating before April 12th of 2024 and meet other conditions. Senate Bill 49 does not legalize adult-use marijuana, but it could create a structure for overseeing recreational sales if lawmakers approve them later. That broader issue is now part of the governor's race. State Treasurer Stacey Garrity, a Republican running for governor, told NBC 10 she would veto any bill legalizing recreational marijuana if elected in November. That puts her in direct contrast with Democratic Governor Josh Shapiro, who supports adult use legalization and included projected marijuana revenue in his 2026 budget proposal. Shapiro's administration estimates legalization would bring in $729 million in the first year, mostly from one-time licensing fees, and about $200 million in annual tax revenue after that. Pennsylvania legalized medical marijuana in 2016, but recreational legalization has not passed. Last year, the Democratic-controlled House approved an adult-use bill, but the Senate Law and Justice Committee rejected it. Polling shows support varies by survey, but the issue remains politically active. For voters and cannabis businesses, Pennsylvania's next move may depend on both the legislature and the governor's race.
In Florida, the debate over recreational marijuana is moving from the ballot box into the 2026 governor's race. Smart and Safe Florida, the group behind the latest adult-use legalization effort, failed to collect the nearly 880,000 verified petition signatures needed to place a measure on the statewide ballot this November. That follows the 2024 vote on Amendment 3. Nearly 56% of Florida voters supported recreational legalization, but constitutional amendments in Florida need 60% approval, so the measure failed. Now, Republican candidates for governor are making their positions clear. Byron Donalds said he does not support recreational marijuana and believes the current medical marijuana system is fine. James Fishback said he opposes recreational marijuana, but would protect medical access for people with legitimate medical needs, including U.S. military veterans. Jay Collins said he is completely against legalization and stands with Governor Ron DeSantis. Paul Renner said Florida already has medical marijuana in the Constitution and that he would campaign against recreational marijuana if it returned to the ballot. That puts the Republican field mostly in one place: keep medical marijuana, but do not expand to adult use. Florida's medical marijuana market is already large. The State Office of Medical Marijuana Use lists over 900,000 qualified medical marijuana patients. The market has generated more than $2 billion in annual sales and includes nearly 600 dispensaries operated by licensed medical marijuana treatment centers. For cannabis businesses, the political picture is difficult. Adult use legalization would have expanded the market, but the ballot path has stalled, and Republican candidates discussed here oppose recreational legalization. Several multi-state operators scaled back Florida investment plans after Amendment 3 failed. Trulieve also faced investor pressure after spending more than $140 million on the legalization campaign. The Democratic side is less settled. David Jolly said he personally voted against Amendment 3, but now supports enacting measures that received more than 50% support from voters, including recreational marijuana. One unusual wrinkle remains. President Donald Trump supported Amendment 3 in 2024, while Florida's Republican candidates for governor discussed here are taking the opposite position.
In Idaho, voters may be headed toward a statewide decision on medical cannabis in November 2026. The Natural Medicine Alliance of Idaho announced that it submitted more than 150,000 signatures for the Idaho Medical Cannabis Act. The campaign says those signatures came from all 44 counties and were filed before the May 1st deadline. The measure is not on the ballot yet. County clerks have until June 30th to verify the signatures. Under Idaho law, the campaign needs valid signatures from at least 6% of registered voters statewide. That number is 70,725 signatures. The campaign also has to meet the 6% threshold in at least 18 of Idaho's 35 legislative districts. If the Secretary of State certifies the measure, Idaho voters would decide the question on November 3, 2026. The Idaho Medical Cannabis Act would create a regulated medical marijuana program. Health practitioners could recommend cannabis for conditions including cancer, anxiety, and acute pain. Patients or designated caregivers could purchase up to 113 grams of smokable cannabis per month or up to 20 grams of THC extract for vaping. The business structure would be limited. Idaho would start with 3 vertically integrated cannabis business licenses, and the state could eventually issue up to 6 total. The measure does not appear to allow home grow. The initiative would also reclassify marijuana under Idaho law as a Schedule II controlled substance instead of Schedule I. It would bar state and local law enforcement from assisting with federal drug enforcement tied to the state legal medical cannabis program. It would also create anti-discrimination protections for people who use or sell marijuana in compliance with state law. But the proposal faces strong resistance from lawmakers. Idaho legislators passed Senate Concurrent Resolution 127, urging residents to reject the initiative. Supporters say the measure is about patient access and point to an analysis estimating more than $100 million in annual medical marijuana sales and up to $28 million in new state revenue. For now, the next key date is June 30th, when signature verification is due.
In North Carolina, lawmakers have filed a bill that could let voters decide the state's next step on cannabis. Senate Bill 1072 is sponsored by Democratic Senators Paul Lowe, Candy Smith, Caleb Theodros, and Joyce Waddell. The bill would place two cannabis constitutional amendments on the November 3rd general election ballot, later this year. The First Amendment would say that possession of limited amounts of cannabis for personal use is not a criminal offense in North Carolina. The second would say that possession of limited amounts of cannabis for medical use by patients with qualifying conditions is not a criminal offense. Both amendments would require the General Assembly to pass laws governing those uses. So the bill would not, by itself, create a retail cannabis market or a medical marijuana program. It also does not define possession limits. Senator Caleb Theodros told the local TV station that sponsors wanted to put the issue to voters because the General Assembly has not acted after years of debate. Senator Paul Lowe said lawmakers are not trying to legalize possession of large amounts. He mentioned possible limits, such as an ounce, 2 ounces, or a half ounce, but those details would have to be decided later. Lowe also said medical cannabis could help some patients move away from opioids. The proposal comes as North Carolina remains one of about 10 states without a medical or recreational cannabis program. Medical cannabis bills have passed the Senate in past sessions, but later stalled in the House. The bill also follows an April report from Governor Josh Stein's Advisory Council on Cannabis. That council recommended moving away from criminalization and creating a regulated adult access market for THC products with protections for medical consumers. Senate Bill 1072 was referred to the Senate Rules and Operations Committee on May 5th. It would need to move out of committee and win support from 3/5 of lawmakers before it could reach the ballot. If voters approve either amendment, the General Assembly would then have to write the cannabis rules.
In Massachusetts, the legal recreational marijuana market could face a statewide vote this November. The proposal is House Bill 5002, titled An Act to Restore a Sensible Marijuana Policy. It is an initiative petition that would repeal the state's adult-use marijuana sales system while keeping medical marijuana legal. Lawmakers did not act on the proposal by the May 5th deadline. The Special Joint Committee on Initiative Petitions recommended no action, which means the legislature did not pass the measure into law. But under the ballot process, that does not end the campaign. Supporters can now collect a second round of signatures. They need 12,429 additional certified signatures. Those signatures are due to local election officials by June 17th and to the Secretary of the Commonwealth by July 1st. If the campaign meets that requirement and clears any remaining legal challenges, the proposal would appear on the November 3rd statewide ballot. The measure would repeal Chapter 94G, which regulates adult-use marijuana businesses, and Chapter 64N, which governs marijuana excise taxes. That would end the legal framework for licensed recreational stores, cultivation, manufacturing, distribution, and taxation. Medical marijuana would remain legal. Adults 21 and older would still be allowed to possess up to 1 ounce of marijuana, including up to 5 grams of marijuana concentrate. Possession of more than 1 ounce but no more than 2 ounces would become a civil offense punishable by a $100 fine and forfeiture. The bill summary also says possession of 2 ounces or less would not be recorded as criminal history or lead to denial of student financial aid, public housing, unemployment benefits, or driving privileges. existing recreational marijuana businesses could apply to become medical marijuana operators through an expedited process. They could also sell remaining adult-use inventory to licensed medical marijuana treatment centers. Massachusetts voters legalized adult-use marijuana in 2016. Recreational stores opened in 2018. If voters approve the rollback, it would take effect January 1st of 2028.
In California, lawmakers are considering a change to how licensed cannabis stores can serve customers. Assembly Bill 2697, sponsored by Assemblymember Gail Pellerin, would allow licensed cannabis retailers and storefront microbusinesses to sell cannabis products to customers in motor vehicles through drive-thru windows. The proposal cleared the Assembly Appropriations Committee in a 13-1 vote and was ordered to third reading on May 7th. The bill would not automatically open drive-thru lanes at dispensaries across California. Local governments would need to approve the option first. Cities and counties would still decide whether drive-thru cannabis sales fit their local rules. Supporters say the bill addresses a regulatory inconsistency. California retailers can offer curbside pickup, which remains from COVID-era changes, but they generally cannot complete sales through a drive-thru window. Assemblymember Jessica Caloza said the bill would make legal cannabis more accessible and help the licensed market compete with the illicit market. Patient access is a major part of the argument. Many customers rely on cannabis as medicine, including seniors, veterans, and people with chronic conditions that affect mobility. For those customers, getting out of a car and walking through a retail space can be difficult. The bill would still require compliance with state and local cannabis rules. Drive-thru sales would need to use a secure, fixed-pane security window with a security drawer or similar mechanism built into the licensed premises, unless the business was already legally operating a drive-thru before January 1, 2027. Supporters also say the change could reduce congestion inside stores, improve retail efficiency, and help keep customers in licensed shops. Assembly Bill 2697 now heads toward an Assembly floor vote. If it passes, it could move to the Senate.
In Colorado, lawmakers are moving forward with a bill that could create a new permit system for temporary marijuana hospitality events. House Bill 26-1117, sponsored by Representative Niketa Ricks, passed the Colorado House by a 33-31 vote. The measure has now been assigned to the Senate Finance Committee. The bill would allow licensed marijuana hospitality businesses to apply for temporary hospitality event permits. Those permits would allow adults 21 and older to consume marijuana at approved event premises. But the bill draws a clear line. Marijuana could not be sold, transferred, or distributed at the event site. Local governments would have a major role. A temporary marijuana hospitality event could only happen in a jurisdiction that first adopts a resolution or ordinance allowing those events. Local licensing authorities would also need to approve the specific event premises. Applicants would have to show that the location complies with zoning, fire, and public health laws. The bill includes several limits. An event could not last longer than 72 hours. A marijuana hospitality business or participating licensee could not host more than 15 events per year. Each event would require a separate permit, and a hospitality permit could not be transferred to another person. There are also location restrictions. The bill would not allow temporary marijuana hospitality events at places licensed or allowed to sell or serve alcohol or tobacco. It would also prohibit them at premises licensed to sell or serve regulated marijuana. For consumers, the bill could create more legal spaces for cannabis consumption, but only in communities that choose to allow them. Consumption areas would need to be kept out of public view. Access would need to be controlled through security personnel or credentialed entry. Events would also need to follow rules on noise, odor, air quality, and ventilation. If enacted, marijuana consumption at a properly licensed temporary event would not be considered open and public consumption under Colorado law.
In Kentucky, the state's first medical cannabis licensing process has passed an independent review by the Finance and Administration Cabinet Office of Inspector General. The report was released on May 7th, 1 year after the Office of Medical Cannabis asked for the review. That request came after public concern, complaints, and questions about how Kentucky awarded its first medical marijuana business licenses. The Inspector General found that the Office of Medical Cannabis created an effective program that was fair and transparent to all applicants. Governor Andy Beshear said the report showed the office met its stated goals of fairness and transparency. The review was broad. Investigators examined licensing rules, application procedures, staff interviews, the lottery process, and the applications of every company selected for a license. They found no evidence of reviewer bias, no conflicts of interest that affected the process, and no irregularities in the license lottery. Kentucky received 5,002 applications during the initial licensing phase. That included 4,998 applications in the first application window and 4 additional applications for safety compliance facility licenses. The first round covered cultivators, processors, dispensaries, and safety compliance facilities. The report said applications were reviewed multiple times by trained staff using consistent standards. Processor and cultivator applications returned for correction were reviewed at least 4 times. Dispensary applications were reviewed at least 6 times. Applicants with deficiencies were given 10 days to correct them. The state used the Kentucky Lottery Corporation to conduct the license drawings. Applicants were de-identified before the drawings, secured lottery equipment was used, and the drawings were live-streamed publicly. The Inspector General did make recommendations. The report said the Office of Medical Cannabis should formally review the first licensing round before launching a second one, update policies and procedures where needed, post formal policies online, and have leadership take part in forums with other state medical marijuana regulators. For patients, the review suggests Kentucky's medical cannabis system is moving forward. For businesses, it preserves the first licensing round while pointing to clearer procedures before the next one.
That's it for this week's Cannabis Policy Roundup. The big picture is clear. Cannabis policy is no longer moving in one direction. Federal rescheduling is facing litigation. State courts are weighing search and hemp questions. Legislatures are rewriting rules around potency, penalties, licensing, and consumption spaces. And voters may soon decide major cannabis questions in Idaho, North Carolina, Massachusetts, Florida, and Pennsylvania. We'll keep tracking every major development. New episodes come out every Saturday at 9 a.m. If you're new here, subscribe to the show. If you're already subscribed, hit the like button to support the episode. Thanks for listening, and we'll see you next Saturday.